Let's state your name for the record.
Deidre Woods.
Thank you.
Welcome.
Your Honor, we would like to set this matter for preliminary examination, and we'd like to address bond, please.
All discovery.
To our knowledge, Judge.
People have their witnesses available 17 or 7, excuse me. Preliminary examination in person, April 7th, 2026, 9 a.m. before Judge
Perry.
Perry.
Okay, thank you.
Bond. Oh, go ahead, Ms. Bond.
As to bond, Your Honor, what's your bond?
500.
So Your Honor,
It's 10% of 5,000.
okay. Your Honor, I believe her bond right now is currently 5,000, 10%. Unfortunately, Ms. Woods does not have the financial capability to post the $500 bond. She does have a case in circuit court with me right now. We're actually just about to get sentenced on that case. Yeah, Judge, we've worked out. Yep, we've worked out a resolution. She has been coming to all of her court dates. She has been very, very interactive, and she's been keeping in contact with our office. Your Honor, obviously this case is going for our case, but she has stable housing. She has children whom she's responsible for, and she has been a part of this community for quite some time. I'm sure the court is very familiar with Ms. Woods. I'm asking that the court consider releasing her on a personal recognizance bond. Any conditions that the court will place on her, she indicates that she will be more than happy to abide by all of them.
But you say this is a circuit court case.
That's correct, Your Honor.
What's her bond on that one?
She's been out on PR bond on that case.
Oh,
yeah.
Okay. Response.
Your Honor, I would object. You originally requested $10,000 cash surety. This case involves Miss was striking the victim twice in the back and once in his head with a hatchet, profusely from his head, and there was a significant amount of blood the officer saw at the scene, as well as his injuries. Miss Woods is a regular around the court. She has previous convictions dating back to 2001. Her most recent, she has a 2025 conviction for larceny, 2025 conviction for false pretenses, 2025 conviction for malicious destruction of personal property, 2024 assault and battery, 2025 assault and battery. I mean, the list goes on and on. So at this point, I think the $500 bond is a gift, given that this case involves someone being attacked with a hatchet. And she does have sentencing up with Judge Conley, I believe, on April 1st. And I have concerns that she picked up this new case while on bond for that. So at this point, I would be asking for bond remaining set, or in the alternative view, put at the people's original request of $10,000 cash surety.
And just very briefly, if I may, we understand the allegations against my client. I have spoken to her, and I've asked her all those questions and informed her that the court will be aware of that information. My understanding, although I do not have much information, is the complaining witness in this matter was previously arrested based on an assault alleged against her. I don't believe that any charges came out from that particular assault. So there weren't any conditions on him at the time, but Your Honor, it is a domestic situation, or at least this was an issue with a person whom she no longer wanted anything to do with. He's at her home. We don't have any proof as to what has happened. I know that there are some injuries that he may have sustained, but again, my understanding is she states that she sustained injuries as well. Unfortunately, her charges are here. I believe that a no contact order will do just fine in keeping the complaining witness safe, if that's the people's concern. I know she has a history. The court knows that. All of those cases have been resolved. She's either fled out, done significant jail time on those cases, but for this particular matter here, she's unable to post the 500, and we're just asking for consideration on that.
At this point, I mean, her exam is coming up in a few days. I'm going to, at least given the allegations and what certainly I know, is what I'm going to deny the request at this time. Certainly after the exam, or at some point it can be raised before Judge Perry.
Okay.
All right. Thank you.
Thanks, Your Honor.
Sorry to wake you up.
Sorry, Your Honor.
Your name, ma'am?
Erica Clemente.
I had before a plea form
That's correct, Your Honor.
that indicates that she's going to plead to the charge of use of methamphetamine, the 1-year offense. Upon her successful plea to that count 2, count one would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Is that correct?
Yes, Your Honor.
May I have her sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So
Yes, I do.
state your name, please.
Erica Clementi.
All right, ma'am, it is this court's understanding that you're going to plead to the charge of use of methamphetamine, the misdemeanor punishable by up to 1 year incarceration and it's $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Yes.
Question about any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor, I do.
Understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am.
All right. Were you on probation at the time of this offense?
No, I was not.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes, I am.
and of your own free will,
Yes,
and because you believe that you're guilty of this offense?
I am.
On February 10th, 2025, at the location of East Clark Road near Prospect, Superior Township, Washtenaw County, State of Michigan, did you have fentanyl in your possession? Well, did you have methamphetamine in your possession?
Yes.
All right. Had you used it?
Yes.
You know what you were using was methamphetamine?
Yes.
Ma'am, I do have to apprise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No.
And have I complied with the court?
Yes, sir.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
April 21st at 10 a.m.
April 21st, 2026, 10 a.m.
Yes.
And Mr. Buckovich did a good job for you.
You did a great job.
See, that's what I'm saying.
Thank you, Your Honor.
I knew he would. Just some people don't appreciate it.
I was on the
Tennessee, don't worry about it.
I have to vote today. Okay.
Thank you so much.
I'm happy to see that.
We'll go back the other way. Your Honor, I think Mr. Childers and I came to an agreement on this matter today. We just need a little time to present the paperwork to the court. So I'm asking for an adjournment of the probable cause conference.
Yeah, there's a problem.
I'm aware of the problem, Judge.
Okay, let's talk about that.
Okay. So the report I'm assuming you're just reading, which I would again assume that is the same one that I have, indicates that Mr. Taylor missed his appointment with Community Corrections on Tuesday. Mr. Taylor indicates to me that he believed that that appointment was today before he came to court, was intending to go there today. Unfortunately, he learned, as I was talking to him yesterday, when I received the email that with that report, that he was actually supposed to be there on Tuesday. So he does want me to let this court know that he's more than happy to comply with anything this court wants him to do with respect to testing, do what he needs to do through community corrections.
Here comes the defense's emotional play: family hardship, children, financial pressure. And to be fair, courts do consider those factors during bond arguments. But when prior bond violations are already on the table, sympathy alone usually isn't enough. This is the moment where the judge has to balance compassion against public safety and compliance with court orders.
Indicates that Mr. Taylor missed his appointment with Community Corrections on Tuesday. Mr. Taylor indicates to me that he believed that that appointment was today before he came to court, was intending to go there today. Unfortunately, he learned, as I was talking to him yesterday, when I received the email that with that report, that he was actually supposed to be there on Tuesday. So he does want me to let this court know that he's more than happy to comply with anything this court wants him to do with respect to testing, do what he needs to do through community corrections. But he's also advised me that he is currently participating in and doing very well in a methadone program, which involves testing already. He tested on
Washtenaw Therapeutics LLC right down in Glencoe Hills. I was actually had my therapy yesterday. Yesterday they drug tested me. They drug test me at least once a week. Usually it's a random test there, but the magistrate said that they would accept the results from there so that I don't have to pay the community corrections fee to do it. That as long as it's through there, my results will be fine. And when I got
So how are they supposed to get there?
that's what we discussed, Judge. I let him know. I've said, well, that's wonderful. You just need to establish all of that with community corrections. And like I said, he did plan to do that. He thought he had to be there earlier today. Unfortunately, the date that they gave him was Tuesday.
So did you go there today?
he told me that
I told him to come here because with this report, I figured you'd want to. My understanding is usually community corrections, once a report like this is issued, they wait for him to see the court. So if that was bad advice, that's what I give him.
Please? So that from the other place?
I signed a release the day I was released.
He has signed a release with the methadone clinic already. He just needs to get everything.
So we can get those testing results?
They'll be able to be sent.
Do I have any proof that he's in this clinic?
I got my methadone bottle from the weekend right here that shows my
Bottle?
Yeah, it's
okay, thanks.
It shows my prescription. It shows the date.
Oh, okay.
You like me to?
So, I mean, he's prepared to go over there right now, Judge.
All right.
Everything's squared up.
Here's what I'm going to do. I'm going to trust you. I don't know why.
I showed up for my last three. Your Honor.
What'd you say?
I showed up for my last three cases, Your Honor. I came here.
Okay, the very fact other cases to show up for.
Yeah. Keep your mouth shut.
No, it sounds good initially. Then it comes out. Well, adjourn your probable cause conference to the 16th. If you need to go over to community corrections now, you're in. No, he's coming over to do. Thank you. Bond will continue.
Thank you.
All right. Go over there. You know,
Say that a little louder for the court.
Sandra Gray.
all right.
There is none yet. He told me I should talk to them over the next week or so via email so I can see about getting you one. Your Honor, with regard to these cases, we are going to be asking to set all three matters for preliminary exam at this time. In the interim, for my client's sake, and for the record, I will be working with Mr. Cook as well as Mr. Vangallo in the circuit court to attempt to get him some sort of offer going up.
Got it. All right. Discovery is complete on these cases.
To the best of my knowledge, Your Honor.
Are there witnesses available the 7th?
Wow, this is actually a major turn. After everything the court just said about repeated violations, the judge still decides to grant bond. But notice the catch. A $50,010% bond plus GPS home confinement. That's the court basically saying, I'll give you one more chance, but I'm watching every move. Do you think this was fair, or should the bond have stayed revoked?
Was in that bag. My understanding is that the device was then cut from his leg. I don't know that my client would admit to doing that himself or that someone else did that on his behalf. However, like I stated,
What? So this is part of the explanation?
this is part of the explanation, Your Honor.
Grab his leg and cut it off? Okay. Go ahead.
Your Honor, he advises that he advises that he was scared at the time, that he wasn't in his right frame of mind, and that he wasn't also on his medications. And he advises that he was getting high, Your Honor.
Get what?
Getting high, Your Honor. And in that regard, like I stated, Your Honor, I would ask to address bond.
Motion for bond reduction is denied. Defendant admitting to the violation. I will sentence him on a state of the violation. on the violation, I'll sentence him to 7 days, credit 7 days, so.
And Your Honor, would the court be willing to consider a release to an inpatient treatment or
Send the order. Oh, I don't think there'll be a problem, is there?
Your Honor, for the record, the people would have an objection to that, given that he was cutting off his tether. I have concerns that he released to treatment, even with the tether order, that would not be sufficient.
But if he's treatment, he's probably not getting high, which is probably part of the reason that the ghost came up and cut his tether off.
I'm not an expert on ghosts, so I can't say that, but
It was scared or something. I will sign an order.
Okay, thank you very much. Yes, yes. I will get the order in today.
Very silent.
Thank you. All right, what are we doing?
Your Honor, we'd like to set this matter for exam,
Discovery is complete.
as far as we are aware.
People have their witnesses available the 7th.
do our best.
Preliminary examination will be set in person April 7th, 2026, 9 a.m. before me. But bond will continue.
Your Honor, may I just bond
Down.
is a bond condition.
Oh, there you go.
Mr. Ellis is currently on a GPS tether for home confinement, actually, not GPS. And we asked this court if that tether could be removed. He has to go to work. He is allowed to go to work, but also he has to take care of his younger siblings. His mom works 2 jobs, so it's hard for him to get around and do all that.
What else does he have? Because
Also,
normally in a case like this one, he wouldn't be put on home confinement. Pardon?
He also has a curfew as one of his conditions. Oh, what other cases? He has an R&O in circuit court, Your Honor.
Is there a response from the people?
Thank you, Your Honor. Your Honor, we were initially asked for a 30 bond in this case. Due to the fact that he was on currently on probation in circuit court. This is where he admitted to possessing a pistol while he's on probation, so he felt that safety of the community was paramount, and we would ask that bond be continued with this current condition.
And Your Honor,
Got an R&O that he was on probation for in circuit. It's like, who doesn't have an R&O? And then he's on probation for that, picks up this, and I could see having on but having him on a home confinement, I don't understand why we're confining him to his house.
and that's why I would ask this court to change that, Your Honor.
That was a rhetorical question. Does he have a failure to appear at all?
No, Your Honor, nothing.
He's set to come back and see me on the 7th. So I'm going to order it this time. I'm going to grant the motion. I'm going to order the tether be removed. I dare you not to show up. Hear me?
Yes.
Because then we won't need a tether because you'll be back there.
Yes, sir.
Am I clear?
Yes, sir.
Thank you.
Thank you so much, Your Honor.
And that wraps up a courtroom session packed with dismissed counts, bond drama, credibility issues, and one very stern judicial warning. Cases like this are a perfect reminder that in court your explanation matters, but consistency matters even more. One bad decision can snowball fast. What's your take? Did the judges strike the right balance today, or were these defendants given too much leniency? Let me know below.